So last time I mentioned that someone was charged with DUI years ago in Madison County for operating a motorized shopping cart. But the defense attorney argued that it was akin to a motorized wheelchair, which is statutorily excluded from the definition of motor vehicle. And the state ultimately amended the charges. Here's my guess on why that happened. When we're talking about what I'll call a regular DUI, the DUI statute uses the term vehicle, which excludes devices moved by human power. Both a motorized wheelchair and a motorized shopping cart have motors. They aren't devices moved by human power, so they should technically fall under the definition of a vehicle. But when we're talking about a DUI where someone suffered great bodily harm, permanent disability, permanent disfigurement, or death, or a DUI where someone suffered bodily harm in a school zone, or a DUI where a person under 16 suffered bodily harm, the DUI statute uses the term motor vehicle, but it classifies the offense as a felony rather than a misdemeanor. That's right. The DUI statute uses both the terms vehicle and motor vehicle, each of which has a different statutory definition. If I were the prosecutor in the motorized shopping cart case, here's just one example of a nightmare scenario I'd want to avoid. The defendant is operating a motorized wheelchair on the street while drunk. A bicyclist is also riding on the street. The bicyclist has to swerve to avoid the defendant. The bicyclist is struck by a passing car and he dies. But if a motorized wheelchair isn't a motor vehicle, then the motorized wheelchair user can't even be charged with felony DUI, much less be sent to prison for causing the death of the bicyclist. Having been a prosecutor myself, you never want to have the case that makes bad law. So if the defendant in the motorized shopping cart case appeals, and if the appellate court discusses the distinction between vehicle and motor vehicle as used in the DUI statute, you're just asking for someone somewhere down the line to argue that the defendant was driving a vehicle, but he wasn't driving a motor vehicle when he harmed or killed someone while under the influence, and therefore he can't be charged with a felony or potentially sent to prison. Just my 2 cents.